You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 114, How to Invalidate Someone Else's Patent Quickly and Cheaply Using a Single Website. My name is Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com, that's D-I-A-M-E-N-T, patentlaw.com, or call me at 424-281-0162. I've had two situations in the past month where someone came to me where they received a cease and desist letter, and the cease and desist letter said that their product was infringing a patent and they must stop selling their product. Now, I've talked about cease and desist letters and responding to them before. I've also talked about how to invalidate someone else's patent using various procedures at the patent office, but those procedures can actually get pretty expensive. And in reality, you might not really care about invalidating someone else's patent. You just want them off your back. But why would they back off if they think they have a good case against you? If you could present evidence to them that their patent is invalid and that you're not afraid to invalidate their patent, then they might back off and you might not have to go through actually invalidating their patent. The other party might not really want you to invalidate their patent and actually will drop the case against you. So on paper, they still have a valid patent because you didn't invalidate it. And it's because they still have this patent on paper, they can still go after other people who just might go into their demands. Now, there's actually a quick way that sometimes works to easily know whether you can invalidate someone else's patent. And it's not the patent websites, because if you start citing other patents or patent applications against them about why their patent never should have been granted, they'll probably just argue that the patent office was already aware of those references and still granted them a patent. So their patent likely still going to be found valid. Those are the arguments they're going to make. And this may not be true. So the quick and easy way isn't a patent database. It's the Wayback Machine, also called the Internet Archive. If you're not familiar with the Wayback Machine, the website is archive.org. And what it does is it keeps a historical record of old websites. Now, why is this important? It's because you want proof that before they file their patent application, they somehow disclosed their patented invention to the public. In the US, an inventor has 1 year to file a patent application after publicly disclosing it. So look at the patent that they cited against you, and you'll see a filing date. You might also see a date of earliest claim priority, which might be different. Note that date too, and either of those might apply depending on the situation. But what you want to do is subtract 12 months from that date. If they disclose their invention 12 months before that date, then that means they can't file a patent application on it, which means that they dedicated their invention to the public. So what you want to do is go to the Wayback Machine and put in that company's website address, and then look at the dates 12 months prior to the filing of the application. Look to see if they had their product on their website. If they did, then there's a good chance that their patent is not valid. An inventor is also supposed to disclose any prior art that might be material to patentability. And if they didn't disclose their own disclosure, that might be considered inequitable conduct, and their patent could be unenforceable. Now, the patent examiner, you would think, why didn't they find this? And why didn't they just cite it against them and reject it? Patent examiners are really mostly looking at patent databases. They're not going on to other places. They're not searching university libraries and other places on the internet. They're really kind of just focused on patent applications and patents to invalidate someone else's or to not grant someone else's patent. So they actually might miss a lot of things that aren't in the patent databases. So the Wayback Machine is a really good resource when you want to respond to a cease and desist letter. What you want to do is take a screenshot of their own website on a date at least 12 months before the filing of their patent application, and just tell them that their patent will be found invalid because they missed the statutory deadline for filing a patent application. There are some other websites that you might want to look into. Check out Indiegogo or Kickstarter and see when they started talking about their product or offering to sell their product. You might want to look at YouTube to see if there are any product descriptions or reviews about their product, or Amazon 12 months prior to filing their patent application. I've had two situations in the past month where I found that a company posted their product online. One was on the Wayback Machine, one was on Indiegogo. And in one of them, they posted their product 12 months and 4 days before they file their patent application, which is 4 days too late. So this is not only a lesson if you receive a cease and desist letter on what to do, but it's also for all you inventors. Once you publicly disclose your invention, note that date, underline it, make it bold, circle it. Make sure you have an application on file within 12 months of that date. Ideally, you should have something on file before you publicly disclose it at all. But if you do happen to disclose it, no later than 12 months should you have a patent application on file. Because believe me, an attorney will find it just like I did. If you filed your application 4 days late, you probably just wasted thousands and perhaps tens of thousands of dollars on a patent application that's worthless. So if you want help with your patent application, trademarks, copyrights, responding to rejections, appeals, or anything else related to your invention, you can contact me directly through my website at diamondpatentlaw.com. That's DIAMENT patentlaw.com, or email me at adam@diamondpatentlaw.com, or call me at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. Or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.